Hi friends, I am Dr. Pratap Singh Rathod. I have done MD in Policy Medicine, and today we'll discuss about Mental Health Act 2017. Before coming to Mental Health 2017, we discuss about it previously. There was a Mental Health Care Act 1987. This act actually repealed the Indian Lunacy Act 1912. So this act enacted to consolidate the amend the law relating to treatment care of mental health persons to make better provisions with respect to their property affairs for matters connected therewith. So, Mental Health Care Act 1987, which repealed Lunacy Act 1912, made certain provisions like changing the definition of mentally ill. Previously, we were called as lunatic, we were called as mentally ill. Then mental hospital to psychiatric hospital, changes relating admission of a patient, then changes related to how to establish mental health facility and how to then related to care, inspection. All other provisions were provided in Mental Health Care Act 1987. This act was repealed by Mental Health Act 2017. This is the recent act which has been repealed, and this Mental Health Act 2017 has some features which we'll discuss in this video. This is an act provide for mental health care and services of people with mental illness and protect, promote, fulfill rights of such people during delivery of mental health care and services. This act mainly enforces that every mental health individual has certain rights which has to be withheld. Every person has a certain right to be treated and to fulfill their rights and promote their livelihood is mainly concerned with this act. Coming to certain silent features of this. So first important feature in this act is advanced directive. So advanced directive is means that every major person, mainly the person who is more than 18 years of age, so that every 18 years of have a right to make an advanced directive in writing in which he wishes to be cared for, treated for mental illness, and the person he wants to appoint as his nominated representative for this care and treatment. So what advanced care directive means is if the person feels that he has some mental illness, so he can, if he is more than 18 years of age, he can make an advance directive in writing which states that he wishes to be treated for mental illness and he can nominate one certain person who will take care of him, representative of him as a caretaker for treatment purposes, he can be nominated. In case if a person is a child is a minor, then legal guardian has a right to make an advance directive in writing. So in case of minor, the legal guardian of that minor can make a writing advance directive that this child should be taken care by this individual or nominated of that person. This feature has been added in the mental health care 27, which is an important feature that every individual, if even the parents teach, even the children's, the pair, the father mother, if the sons or daughters doesn't take care of their children of their parents, they can, if they make advance directive, they can make advance directive regarding that. They can nominate a person whom they believe to be will take care of and can be useful for the treatment. In this act, it also been decriminalized under Section 309. Previously 309 in IPC, that is Indian Penal Code, which now it has been replaced by Bharatiya Nyaya Samhita, in which this section is not provided. Previously, it was 309 was there for attempt to commit suicide. So if any person who tried to commit suicide was punished for about 2 years, but it has been now decriminalized. Every person who will attempt to commit a suicide is considered as stressful individual. So government should provide has a duty to provide care, treatment, and rehabilitation to such person having severe stress and who attempts to commit suicide. So the government has to provide treatment to such individual so that he doesn't commit again such type of act in the future. In this act also there is electroconvulsive therapy which should not be performed without the use of any exercise and anesthesia, and electroconvulsive therapy should not be performed on any minors. There should not be any sterilization of any man or woman for just because the person is mentally ill. This has also been removed. The person should not be chained any manner of form. So any mentally ill person, if he is there, should not be chained. This act also have provisions to how to establish the Center Healthcare Authority. So Central Health Authority, state level health authority, state mental health authority, and mental health review boards. So these are the things which have been added in 2017 Act. So this they provide guidelines related to what are the things, what are the way how this authority has to provide, how the authority has to function, and what are the functions, what are the duties are all been provided. This also provides provisions for registration of mental health establishment, like a psychiatric hospital, nursing homes. So they also provide every any establishment which uh, provides that mental illness, provides psychiatric hospital, provides treatment for mentally ill, has to be get registered in the state authority for treatment, so that they can provide a healthcare provider for mental ill purposes. Any admission in mental health establishment shall, as far as is possible, should be independent admission. So every individual can be admitted individually, except when such conditions exist as to make supported admissions unavoidable. So if any supported unavoidable, then individual has can be independent admission can be done. Every mental health establishment should be registered with central or state mental health authorities, as I mentioned. So only when it is can registered only, then when only they can provide the treatment for any mentally persons. Restraint and seclusions. So this has been completely separately in act. They have mentioned about restraining and seclusion of a person, of a mentally ill person. Any mentally ill person should not be subjected to seclusion or solitary confinement. So the person should be provided as a in a psychiatric hospital. He has to provide with social contacts. He should not be secluded from the society. If physical restraint may be used, only be used when it is only means available to prevent imminent and immediate harm to the person concerned or to others for a period necessary to prevent risk of significant harm. So if restraint is necessary, it should be provided only to the brief period till he can be made in control, or to prevent that he should not harm himself or harm any others. And this has to be accepted by the in charge physician. He has to mention what period he has to be attended, and he has to authorize, then only he should can be restrained. The act also provides certain rights for mentally ill person. The first right is a right to have access to mental health care and treatment. So every individual or mentally ill person has the right to healthcare treatment. He has a right to get treated with any mental health establishment. So mental health treatment and services should be free of any charge and no financial cost. So every mental ill has can should be treated free of cost. So the government has to provide provisions, provide medications, everything to the mental ill, and should be treated free of cost. That is also one of the right. Every mental ill has a right to live and part of the society. So though he has mental ill, he should be a part of society, and he has a right to live in with the society. He has a right to live with dignity. He should not be treated as outcast and should be live with dignity. He has a right of a confidentiality. So he's any illness, if he is suffering, he also has right of confidentiality. He should not be disclosed to any other person. He also has a right to refuse treatment if he doesn't want to get treated. He also has a right to treatment. He has a right to visitation rights and communication rights. So every mentally person, when he is admitted to mental health establishment, he has a right to be get visited from his family members or family friends. He has a right to privacy also. If he doesn't want to get visited, he has a right to the privacy. He also has a right to access basic medical records. This again, this provided if we consent has to be taken from the person who is records has to be taken within 15 days. It can be should be provided when it is asked. If he is, doesn't, if we believe if the doctor believes that the person is not in capacity of taking a records, he should come to the medical review board regarding the same, and then it, provide the information that he doesn't believe that the patient is in capacity to have records. Then he can skip the records. This right can be skipped. But if the doctor believes that he has capacity to take the records, then he should provide the medical records. Then Acts provides certain criteria for admission of a mentally ill, treatment and discharge, certain guidelines which are to be followed. So first of all, admission of any person who is independent, who wants to get admitted independently and get treated. So any major person who considers himself to be mentally ill person and desires to be admitted to the mental health treatment may request the medical officer in charge of medical health establishment to be admitted as independent a patient. So if a major person who is 18 years of age believes that he is mentally ill and requires to be admitted, he can go to a mental health establishment and request to get admitted. The medical officer in charge of medical should admit that person, and if he is satisfied that the person requires admission and will benefit from treatment, then the request for admission is on his free will without any undue influence. He should look that the person is not under any influence and should be admitted. And if he believes that treatment is necessary, he should be get admitted. The consent of relative or caregiver is not necessary in this case. An inmate may also get discharged without consent of the medical officer. Since he is independently has been admitted, he has a right to get treated, discharged when he requires. Admission of a minor who is mentally ill. In case of minors, the nominated representative, as I mentioned, advance directive, the nominated representative should apply to medical officer in charge for mental health establishment regarding that he wants to get admitted in mental health establishment. Such minor may be admitted if two psychiatrists or one psychiatrist and one mental health professional have independently examined the minor and both have independently concluded that the person is mentally and requires to be admitted. So any minor, if has to be admitted, it has to be examined by two psychiatrists or one mental health professional, and they individually has to conclude that the person is having suffering from disease and requires admission. Nominated representative should stay with the minor for relative to entire duration of the admission. He should be present with him. Nominated representative of the guardian or the guardian, if he is present, has to be present. If the nominated representative requests discharge of minor, he should be discharged. Again, the nominated representative, as mentioned in advance directive, will be the guardian of that person, and if he requests to discharge, then the patient minor has to be discharged. Next, coming to admission of the person who requires treatment up to 30 days. So admission treatment of a person with mental illness with a high support needs up to 30 days. So in charge of medical health establishment should admit every such person upon application of the nominated representative of a person. So any person who gets admitted has a mentioned individual admission may be discharged within 5 days. In certain times, the in charge may feel that the person has to be maybe requested from the nominated representative that person should be admitted or may require higher support. If a person has been independently one examined by on the day of admission or on the preceding 7 days by once by a psychiatrist and one mental health professional or medical practitioner, and they all believe by individually that he is required to be admitted, then should be admitted for limited for 30 days. So once they believe that higher support is required, so this is excluding the independent admission. Here, the nominated representative comes to the mental health establishment to get admit the mental health person whom he represents. And once he is examined by one psychiatrist or one mental health professional or medical practitioner and believes that he requires treatment, then he should be admitted for limited for 30 days, after which the person continues to remain admitted in mental health establishment as an independent patient or has a right to leave mental health establishment. Next, admission treatment of a person with mental illness with high support needed beyond 30 days. So if a person with mental illness requires continuous admission and treatment beyond 30 days or has been discharged, he will be admitted if the nominated representative applies and if two psychiatrists have independently examined and mental ill person in the preceding 7 days and both independently concludes that the person has mental illness of severe that he requires admission and treatment. So here again, if during treatment of 30 days, after treatment of 30 days, if again the nominated representative gives application that he requires higher support, then he should be examined by two psychiatrists. Proceeding the 30 days, within 7 days he is to be examined and he should be concluded that the person requires treatment, then he can continue treatment. Such admission should be reported to the concerned board and will be limited to 90 days in first instance, which may extend to 120 days and thereafter 180 days each time by the board. So if the person requires more than 30 days, it has to be informed to the board, mental review board, that the person requires more than 30 days. Then it will be extended to 90 days. Then afterwards, it will be extended to 120 days, and after that, it is equal to 180 days. So in the increment manner, it will be increased based on how many days treatment he requires. So first 30 days, he can be admitted. After that, he has to be informed to the medical board that such a person is present who is required treatment is required more than 30 days. Then each time he extension is required, it has to be reviewed by the board that such person has to be admitted beyond 30 days. Then such certain duties of a police officer in respect to people with mental illness. Every officer in charge police station should take under protection any person found wandering at large whom the officer has reason to believe has mental illness and is capable of taking care of himself or to risk to himself others due to mental illness. So if any police officers comes into contact with any person who wandering in the streets or whom they believe that they require some attention of a mental illness, they has to be brought to the mental to the has to be brought to the nearest mental health establishment for assessment for mental health care needs. And so once the in charge mental health representative examines the case and believes he is required treatment, he should be admitted. Next, reporting of the magistrate of a person with mental illness in private residence who is ill treated or neglected. If certain times any mentally ill person may be present inside the home, may be present in the restricted in the residence, may not be treated, and sometimes he may be ill treated. This may come to the notice of a police officer. Then the officer in charge of police station who has reason to believe that any person of mental illness is being ill treated or neglected, or if any person reports to a police officer of such case should report to the magistrate. So if a police officer comes with the complaints that the one individual has been present in a home and who is a mentally ill and who is not treated well or been neglected, not giving proper food, sanitation, then that report has to be sent to magistrate. Then the magistrate may order to produce the non-mentally ill person before him and may order in writing that the person is sent to public mental health establishment for assessment and treatment if necessary, or to admit for not more than 10 days and carry out an assessment. So magistrate after being examine the case may send the patient to the public mental health establishment for assessment, and he should be admitted not more than 10 days to carry out an assessment. Then the in charge of the medical assessment should submit a report to the magistrate concerning whether the treatment is required or admission is required for 30 days or beyond 30 days, and whatever the things is there, the in charge has to report to magistrate and continue the treatment as required. Some things rights of a mental health person if the person is a prisoner. If a mentally person is a prisoner, he should be admitted to a psychiatric hospital by any or by order passed by the appropriate authority under Prisoners Act 1980, Air Force Act 1950, Army Act 1950, and Navy Act 1957, and also some sections of Bharatiya Nyaya Samhita also provides such a section that every prisoner has to be treated. If he has some psychiatric illness, psychiatric illness, he has to be treated as a normal individual. People in custody institutions. If any person who is present in the custody institution and he is suffering from mental illness, he has to be treated equally. If it appears to a person in charge of a custody institution like beggar homes or orphanages or women's protection homes or children homes, that any resident of a institution has mental illness, he has to take such residents to the nearest mental health establishment. The in charge of mental health establishment should assess the person with mental illness and treatment required according to provisions of admission and treatment. So, if any person who is present in the custody institutions like beggar homes or orphanages or children homes, if the person, if they believe that treatment is required, then that person has to be taken to mental health establishment. The in charge in the of the mental health establishment assess that the person and provides the admission and treatment as the act has been dictated. Admission of escaped mental ill person. If the person is escaped from any psychiatric hospital or mental health establishment, he can be taken into protection by any police officer. The police officer, if present, he can take care of that and request in charge of the medical establishment and should be sent to medical health establishment immediately. So if any person is escaped from a mental ill person, the any police officer in charge, they can should be contacted. That person has to be brought to the mental health establishment immediately, so that he not only harms himself or then harms others also. These are my references. Thank you.